Restaurant Unstoppable, inspire, empower, and transform the industry. With excitement, allow me to introduce to you today's guest, David Lizerbram. David, are you feeling unstoppable today?
I am.
Yes, I cannot wait to get into this conversation. So just a little bit more about why David is here. In the network, I'm making it very clear, very plain that if you guys have issues, if you have challenges, I'm not the guy that has all the answers, but I can usually find the gal or girl or guy who has the answer. We'll get them on the show. We'll learn together. And somebody in the network came to me and they had questions about trademarking. And I said, you know what? I don't have your answers, but guess what? I had a trademark Restaurant Unstoppable, and I discovered this guy, David, who has his own podcast around the name of the podcast, host of Products
of the Mind.
Of the Mind. And then you also have Intangible Assets, which is a second podcast. And I mean, I just trust you because I
have a lot of podcasts.
Yeah. You're the attorney for John Lee Dumas, who is somebody who inspired me to start my own podcast. And any time that John is out there promoting a tool or a service, I just listen and I pay attention because he doesn't stand by products he doesn't believe in. So basically you're here because we trust you. I've used you personally. I know you're going to have answers, and we're going to be covering, first we're just going to define some terms, and then we're going to go over how to choose a strong trademark. We're going to cover things like the number one thing that gets people in trouble and going through the trademark process. But before we get into that, let's get that motivational, inspirational ball rolling with a success quote or mantra. What do you got for us?
Well, I am a lawyer, so I do like to say that, what you don't know can hurt you. But the flip side of that is that knowledge is power. So, don't be too scared of all this stuff. Be sure that, you get yourself informed and educated, and then you'll be way ahead of the competition.
I'm guilty of this myself. Like when you don't know something, it's scary. And that scariness will make you not want to just do the thing because you don't know what to expect. And 9 times out of 10, it's a lot easier than you think it is. And don't let not knowing the answer or being afraid of something stop you from doing what's necessary in your business. I mean, I probably waited 6 months longer than I needed to get my business trademarked because I thought it was going to be a big gross process and stupid expensive. I had to spend some money, but it wasn't bad. Like literally our engagement back and forth. Like I told you I needed a trademark. You sent me the paperwork, told me what I needed to do. And it was really painless.
Well, I appreciate that. I'm glad you had a good experience.
Yeah. So let's just get into it. So what are the terms we need to know? Just lay that foundation for us.
Yeah, absolutely. I never wanted to be the attorney who uses legal terminology that's confusing or that people don't understand. So if I say anything that, you think somebody might not understand or I haven't defined it, please stop me. First thing I have to say, just a little disclaimer, because I am a lawyer, is while I am an attorney, I'm not your attorney by virtue of doing this. This is not legal advice. Eric, I am your attorney, but that's a side issue. But for people who are listening, of course, don't take this as legal advice. I'm not speaking to your particular situation, and you have to consult an attorney yourself if you have particular questions. And I can do Q&A and answer questions that are generally informative, but again, I'm not providing legal advice to anybody in this format. Just kind of jumping into it, the topic that Eric wanted to discuss and thought would be valuable for the Restaurant Unstoppable community was trademarks. And the first thing that people need to know is, what is a trademark, right? Because that's a term that gets thrown around. People get confused. They often confuse trademarks with things like copyrights and patents, which are not the same at all. They're maybe sometimes considered in the same category of intellectual property, but each of them is totally different. So they don't overlap for the most part. Okay, what is a trademark? The most basic definition is that a trademark is anything that identifies you or your company as the source of a product or a service. So common types of trademarks can be business names, brand names, logos, taglines. I work with many restaurant and hospitality type businesses. So it could be the name of a restaurant or a bar or whatever it could be. Could be a menu item, could be a physical product that you sell. Any of these things could potentially be trademarks and just fall under that category. So it's pretty broad, but 99% of the time when I'm working with clients, what they're worried about is the business name, brand name, what we call word marks, and then things like logos sometimes and taglines and that kind of thing.
So when it comes to taglines, It's like, anything that's associated with your restaurant that might be like a subtitle of the title. Like, I don't know, like I can't think of anything immediate that comes to mind. But when I think of taglines, I'm curious because being John Lee Dumas's lawyer, I also asked for a success quote or a mantra. Is that something I should be worried about? Is that, for example, I guess is what I'm asking.
I see what you're saying. So like that's a thing, that you do in your podcast that identifies you. Somebody listens to that and they go, oh yeah, Eric does that all the time. That's kind of part of his vibe. That's what he's communicating. Maybe I would say that could be a trademark. I'm not really sure. I'd have to give it some thought. Because it probably is the type of thing that there are other people out there who are doing it, asking for mantras or success quotes or, a quote that's motivational. You hear that a lot in the podcast world. So it has to kind of be unique to you in order to really function as a trademark. We'd have to think about whether that really fits and how you're using it and so forth.
And would you have to be mindful of the fact that you have a tagline if you go to a lawyer and you're like, I want to, trademark my brand, the name of my business and this logo? Would you also have to trademark specifically the tagline, or would you have to be like, would you have to like spell that out? I'm assuming you would.
Yeah, sure. Okay, so let me just kind of define a couple things because that's a really good question, but it brings up some issues that we wanted to get into. So first of all, when we talk about trademarks, like when somebody talks about trademarking something, right? People say that to me all the time. Hey, I want to trademark this, right? I don't really use that as a verb exactly, but I understand what people are saying. A lot of times what people are thinking when they mention that is filing something with the United States Patent and Trademark Office or a trademark office in, let's say, a different country, if that's where they live or work, et cetera. When I think of the trademark world, because I've been doing this for almost 20 years, helping clients, protect their brands, I think of it a little bit more broadly, right? So first of all, you can get trademark rights. You can gain rights, legal protection in a trademark, a word, phrase, logo, whatever, without filing anything with the trademark office. That doesn't mean you shouldn't file, and we can totally get into that. It's very valuable. But in the US, you can gain rights in a brand just by virtue of using it. It's called goodwill, right? So you see, a bottle of Coca-Cola and you have a good feeling about that brand. You've had Coca-Cola before, you like it, it's good quality as opposed to some other generic brand or something you haven't heard of. That's goodwill. That's a trademark. Now, of course, they have their trademarks registered, but even, aside from that, they also have this kind of common law goodwill that's associated with the brand. And the same thing applies to a podcast, a restaurant, whatever it might be. If you have customers, if you have users, listeners, clients, whatever it might be, who are familiar with your brand, they identify it, they have a good feeling about it, they understand the quality and so forth. Those are trademark rights that you're developing. In terms of, kind of what we talked about, the uniqueness, that's where we get into what I like to say is the number one thing that most people don't know about trademarks that gets them into trouble. And this is a conversation I have with clients literally every day for the last 20 years. Yeah. So it's very common. And people, miss this stuff all up and down, whether you're just new to starting a business or whether you've been doing it for 30 years or whatever. It's just something that people haven't really gotten their minds around. But in the US and many other jurisdictions, like I said, trademark rights are acquired through use. Just using it in commerce, you're acquiring legal rights. So what does that mean? That means that even if somebody hasn't registered something with the trademark office, they may have legal rights. So if you're coming up with a new brand, let's say you have a new name for a restaurant that you've developed, right? And you want to start using it. A lot of times what people will do if they're, at least trying to do the kind of first step here is they'll look in the United States Patent and Trademark Office website, uspto.gov. You can search there for trademarks and they'll type in the name and nothing comes up and they go, great, I can do it. I've got the trademark or I can file it or my lawyer can file it and I have nothing to worry about. Unfortunately, that's not how it works. Because people can acquire rights without registering with the trademark office, that means that searching the trademark office database doesn't tell you everything you need to know about what's out there. For that reason, when people come to me and they say, hey, I need help with the trademark, I want you to trademark this or register, whatever, what I'm really thinking is, okay, number one, we have to do a search to see if that name, that brand, whatever is available. to make sure that there's nobody else out there who's using that brand or something similar in a similar context, right? So if somebody has come up with a name that, is the same name as your potential restaurant, but they're using it on, I don't know, airplane parts or something, a totally different type of product or service that has nothing to do with what you're doing. Most of the time, that's not an issue from a trademark perspective. But if they're using it for a restaurant, food product, hospitality, something like that, then you potentially could have a conflict. Now, every conflict's not the same. It's not all black and white, yes or no. There's gray area, but a lot of what I do and what trademark lawyers really do in terms of what you're paying us for and what the good stuff is searching and clearing, seeing if those brands are available, if anybody else is using it, even if they haven't registered with the trademark office or anything, if they're out there, identifying those conflicts. Then I'm working with the client to understand, okay, we maybe have found some conflicts. How serious are they? Where are you at? What's your risk tolerance? Every client has a different situation. So again, I'm not just saying yes or no. It's okay, here's what you're looking at. Let's identify the issues. Think about the pros and cons. What are your options? What are you going to do in terms of going forward? Then once we've gotten through that search and clearance process and the client is ready to move forward, then it's the time to actually file the registration with the trademark office. So I know we kind of jumped ahead in our agenda a little bit, but your questions were totally on point. So I want to answer them and give you that context.
No, and like listening to you talk, it reminded me of what happened with you and I, and like what happened where I wasn't starting. I mean, I had already started. Theoretically, I probably should have came to you before ever starting my podcast, but the cash flow wasn't there yet for me. But the reason why I came to you was because I think somebody started an Unstoppable Hospitality podcast, and I was like, "Are you fucking kidding me? Like, that's really close. Like, is that cool? Like, should I be trademarking myself right now?" So what, like, I guess from what I just said, what was going through your mind as far as like what you need to be aware of?
Yeah, I mean that there's typically there's a couple rules about trademarks that are really simple. It's one of the areas of law where there is a lot of complexity, but there are also things that are as simple as understanding the speed limit, right? So one of which is, the first to use, typically it's considered the senior user, right? So if somebody's using the same or a similar, let's say it was the same, trademark. Somebody came along and they were calling themselves Restaurant Unstoppable. Maybe it wasn't a podcast, maybe it's a YouTube channel or something, right? But it's basically the same type of thing. You would be, in that case, the senior user. You've got the priority. You've been using it the longest. People identify you with it, and somebody else comes along. Generally speaking, you have the stronger legal position.
So even if you didn't see an attorney from day one, before you ever like started your business, opened your restaurant, whatever, if a podcast, whatever it might be, as long as you started and there's evidence that you were around before the actual trademark was created by somebody else, you have a leg to stand on. That's kind of how I'm interpreting what you're saying.
That's the general sense, but you've got the kind of like theoretical legal sense, which is true, but then you've got the practical reality of like, what is it like to run a business and how can you actually accomplish, perfecting these rights, using them and so forth, right? That's where getting the trademark registration with the U.S. Patent and Trademark Office is very beneficial because it gives you certain advantages, right?
Yeah.
One of which is that essentially you have the benefit of the doubt. Let's say if there was a legal dispute, the person who's holding the trademark registration is presumed to be, like in court, the person or company who has the real legal rights. That doesn't mean it's the final definitive word, but the other party is kind of on the defensive. Now, you don't necessarily want to be spending your time in court because that's very expensive and time consuming, right? But if you know that you have that advantage, that you've got that registration, that's going to make most other people just kind of back off because it's like they don't want to be in court either, right? So they know, okay, well, if they speak to a lawyer, the lawyer's going to say, look, they have the trademark registration. So they're already starting from a position of strength. Do you really want to attack that and try to convince the court that there is a vulnerability in the trademark registration? If you guys are big companies, maybe yes. But if you're, small to medium-sized company, startup, et cetera, you may not have that, luxury to fight that fight. So that's one of the advantages of trademark registration. There's a lot more advantages, and I can go down that list, but I don't want to, just kind of run out the clock with all that.
My ADD is kicking into like hyperdrive right now too. We do have an agenda, and I should probably bring us back to the agenda. Yeah. We were going to define the terms that are important to understand. You defined trademark. You pointed out that trademark is not the same as a copyright or a patent. Were there any other terms you wanted to define before I start pulling back some layers?
Yeah, I mean, I think people get confused about some of the little nitty gritty details of this. So, like, people will use the term service mark and trademark. They're really very similar. If you hear, I basically just always say trademark just because it's simpler. There's not that much of a legal description distinction. Now, technically, you could say a trademark applies to a product. So, this is like an Apple product. They have their logo, right? That's a trademark, as opposed to a service mark like having a restaurant is a service, a law firm is a service. So you could say, okay, well, that's really a service mark, but that's the distinction doesn't really matter too much. We can just say trademark. Another thing people get confused about is those little symbols or logos. So like you have the TM and then you have the R in the circle. So the TM just stands for trademark, capital T, capital M. That's not really legally controlled in any way. Meaning, let's say you open your restaurant today, you can stick TM next to the logo, next to the name, whatever. Nobody's stopping you from doing that. It doesn't prove anything legally. You don't have to do it, but you can do it and it's fine. You're just saying, hey, this is my brand. The R in the circle is the one that is legally controlled under federal statute in the United States, meaning you can only use the R in the circle in connection with a mark, so word, logo, whatever, that has been registered with the United States Trademark Office. That doesn't mean you filed for it. It means you've gone through the whole process and you've obtained the actual registration. That's the only time you can use that R in the circle. And let me just say one thing. This is where a lot of people get in trouble, right? They hire somebody to create their logo, and then the logo designer just sticks the little R next to it and goes, oh, here you go. Here's the trademark symbol. And the logo designer doesn't know this stuff. They're not a lawyer. They haven't had the benefit of listening to this fabulous episode of Restaurant Unstoppable and have all this info. So, you can't rely on them. And that's not their job. So you always have to be mindful as a business owner. You just don't want to use that because that is something where you could get in trouble by, it's technically fraud. Nobody's going to jail for it, but you're not supposed to be doing that. So just something to look out for is which of those symbols are you using and when can you use them?
So what are the benefits of using it? Like, the obvious one is you're telling people like, don't mess with me. Like I've gone through the process. Like if you try to use these marks, you're going to run into issues because it's trademarked. But does it help you maybe look like more of an authority? Like you have your stuff together, like more professional? Is it worth going through those motions?
So a couple of the advantages of going through the registration process. So one is that what happens is, like I said, when you're, looking at open a restaurant or start a brand, whatever it may be, a lot of people will do that search of the Trademark Office database, or they'll have a lawyer do it. It's free. You can just do it. Anybody can go on uspto.gov and do it right away, right? So let's say Restaurant Unstoppable. Somebody comes up with maybe somebody hit on that same exact brand name, right? And they think that's a good name. They haven't heard of you. They just came up with it individually. They go to the Trademark Office. They type that in. They see Restaurant Unstoppable is already registered, and they go, okay, well, that's already taken. I can't use it, right? So that's happening all day long. You don't even know about it. But that's a problem that never came across your radar. You never had to deal with it. It just, bounced off the invisible shield of the Trademark Office. And I know that that's happening all day long because I'm doing that on my end for clients. They're asking me to search something. I search. I say, you can't use that because somebody else already has it. Boom, that person on the other end of that, they got that benefit from me doing that and they didn't even know, right? So that's one benefit that you get. Another thing is that kind of validity, showing that you're, you're taking all the right steps in your business. A lot of people want to start a brand, like a restaurant brand, grow to multiple locations and maybe get acquired or get investors, partner with, more, financial people, whatever it may be. Having that registration often is helpful because it checks off one of the boxes, right? So if you're going to invest in a business or you're going to acquire a business, there's a whole list of due diligence. You want to make sure the financials are in order and this and that and everything. They have what registrations. One of those things on that list is the trademarks. Is that registered? Well, if you've already done that, boom, that's one thing. That's one reason they don't have to say no to you in terms of this potential business deal. That's already taken care of, et cetera. In addition, if there is ever a legal dispute and somebody infringes on your trademark, meaning they, use it and they know that you're, that you have the right claim, but they just blow you off and you were to sue them, you are entitled to up to triple, meaning 3 times damages of their profits potentially from using the trademark and your lost profits, as well as in some cases, attorney's fees and costs. That's only true if you have the registration. If you don't have the registration, then you don't have that. And again, I'm not saying everybody wants to run to court all the time. I'm not a litigator. I never go to court. That's not my job. So it's not to my benefit to tell people to do that. But if the other side knows that you have that power and that ability, that makes it more likely that they're going to back off or comply with the cease and desist or whatever the case may be. So these are just some of the advantages of going through the trouble of getting the registration.
And you're pointing out some key things, and I'm actually really proud. I feel like I need to sit up tall right now because we have Greg Lindsay who's joining us, who is the owner of the Jewish Deli. Is this trademarked? No, he's shaking his head. No, we'll save your questions for later.
Okay.
So
anybody who owns a deli is good with me. I grew up going to delis, and we need more of them.
So, I mean, I do have one thought that came to mind that when you might want to get a trademark is if you have intentions, if it's your dream to scale, if it's your dream to build something and sell it, go through these motions early, because you don't want it to spend time building brand awareness to only have that brand change 5 years from now when you're ready to sell, or 10 years from now when you're ready to sell. That's what's going through my mind. So it's just being good. And you're, like you said, we learn a lot about when you're approaching investors or anybody who might buy in. If you can eliminate the no's, if you can create a path of least resistance to sell or have people acquire your business, just going through those motions early on just helps get a yes later, is kind of like the big underlying message I'm pulling. Correct me if I'm wrong.
Yeah, exactly. And, you might be starting a business or in an early stage and you're not even thinking about selling, but, you want that business to thrive. So what's going to happen one day at the end of the day? Either you're going to sell it, your heirs are going to sell it, or, it's going to close, right? I mean, or they're going to inherit. I mean, there's only so many things in the end of the, time that's going to happen, but keeping the business going and then, eventually being able to sell it, whether you want to retire, grow, whatever it might be, the earlier you start thinking about those things, the better. And just kind of on that point, again, just to kind of clear this up in terms of conflicts, my clients learn. I have clients that have been with me for 10, 15 years or longer. The earlier they come to me with potential brand names and things like that, the better. Meaning, an ideal situation is somebody comes to me and they say, hey, I'm looking to open a restaurant. Here's 5 potential names that I'm thinking of. And then sometimes I can rule, okay, these 2 aren't going to work. I can tell you right away because X, Y, and Z, right? Then we, start to narrow it down. We do searches, whatever, and we come up with that one that's like really solid and really good. That's often not possible because, sometimes people just can't afford to get into that situation, or, they're not thinking that far ahead. They're just too consumed with getting the business started, and that's fine. I work with people in every stage, but the earlier you are practically able to work with an attorney, even at a very low level, just to kind of clear things, the less likely you're going to run into issues as you go along.
Okay, so we've covered the definition of trademark. We talked about how it's not a copyright or a patent. We talked about the trademark symbol in the R, the circle around its symbol. We've talked about the difference between service mark and trademark. Any other terms we have not covered that you're hoping to cover before we move on and get into how to choose a strong trademark?
Yeah, I think that basically covers it.
And we've defined some terms, and now we're going to talk about how to choose a strong trademark. What do we need to be considering when it comes to choosing a strong trademark?
Well, some of the things we already discussed was, conflicts, seeing if somebody else is out there. How do you do the search to make sure that as best as possible, you can determine that there's not a conflict with somebody who has rights kind of before you came along? That's a big part of choosing a strong trademark, but there's some other factors beyond just conflicts. There's things that just have to do with the actual brand itself, right? And typically when we talk about this, I'm talking about word type brands, not logos, which are a separate thing. They're important, but word marks, like the name of a restaurant, let's say, or the name of a specialty menu item or a food product, right? So we like to say that trademarks fall on a spectrum of, weak to strong. So in terms of the weekend, not the weekend, like what happens Friday, Saturday, Sunday, when restaurants probably make all their money, but the weaker end of the spectrum, first, you have terms that are generic. Those are not protectable at all. So like pizza shop, deli, those are not protectable. They're generic terms. They just are the term in the language for the thing that it is. Nobody, anybody can use it. Nobody owns it, etc. Now, a generic term in one context can be not generic in another. So apple for an apple juice, whatever, that's generic. Whereas, apple for an Apple product, that's a trademark. So it depends on the context, but you understand what I'm saying, like in terms of, your space, terms that are generic are not protectable. On the way other end of the spectrum, the strongest end, are marks that are what we call arbitrary or fanciful. Again, just kind of using the terms that we use in the legal world, but they're pretty easy to understand. Like something like Starbucks, in terms of restaurant context, super strong trademark because that word doesn't mean anything. It doesn't have anything. Before Starbucks coffee came along, nobody would have associated the word Starbucks, which I don't even know if it means anything, with coffee. It's just a random, completely, total arbitrary choice. Whereas something like Java or whatever, that is a coffee related term. So it's not as strong inherently as something like Starbucks. Now, Starbucks has also gained strength by registration, by marketing, advertising, getting so everybody in the world knows their product. But they're starting with a really strong trademark to begin with, right? And now it doesn't have to be a word that doesn't have any meaning, like Domino's for pizza. That's another super strong trademark. Again, if you're playing Domino's the game, that's a generic term, but in the context of pizza, it doesn't have any meaning. It's just basically a random term that they use and they marketed and branded and so forth, and it became very strong. Where it gets to be a little bit more challenging are terms that are what we call descriptive. Just because a term is descriptive doesn't mean that it can't be protected at all, but it's a little bit more difficult to protect. Descriptive terms are those that identify or describe some feature, source, etc. Some aspect of the business, the product, the service, whatever it may be. Even Restaurant Unstoppable, just to kind of point you out, is somewhat descriptive, right? It's not totally arbitrary like Starbucks, right? It's not
business unstoppable.
Right. Yeah. Exactly. It's not, restaurant podcast, which would be generic basically, right? So you're kind of in the middle there. It's somewhat descriptive, but I would say strong enough that it's okay. But, you kind of get into that gray area. Now, sometimes it's important and good to have your brand be descriptive in some way, shape, or form. The term, the wording that you use in your brand can have an association with the product, services, the type of food, whatever it may be. And that's okay. That doesn't mean that it's a loser or a bad trademark. It just means that there may be a little bit more work, a little bit more thought put into it in terms of how to protect it and what that process looks like.
So if you get descriptive, you're getting more protective. For example, Restaurant Law Unstoppable.
Right. Yeah, that's pretty descriptive. So if I was going to start that podcast, it would be...
Don't you dare, man.
Yeah. First of all, it'd be a conflict of interest unless we went on together. Maybe this episode will be such a hit that we'll just spin it off to its own brand.
Okay. Let's talk after.
Nobody take that idea. But again, without kind of getting too much in the weeds, you want to just take a second to think like, okay, this brand that I'm thinking of, let's say for the name of my restaurant, does it have kind of more of that Starbucks or Domino's vibe where it's pretty random and it just is a word that I like or combination of words that I like and I can kind of play off of that? Or is it something that is a little bit more on target and descriptive? Now, again, just because a term has a descriptive element doesn't mean it can't be protected. Like Kentucky Fried Chicken, right? Very descriptive, geographically descriptive because that's Kentucky, that's a place. And fried chicken. Fried chicken is a generic term, right? Anybody can say fried chicken, right? But Kentucky Fried Chicken, because they spent so much money and energy advertising and growing that brand, it became a distinctive trademark. Eventually, I think they pivoted to KFC, which is even more kind of abstract. And they probably did that on the advice of their trademark lawyers. But still, it's not that it has no protection. There are terms that are very just like Best Buy, right? That's a strong brand just because they've been around so long. But if somebody was starting a business today and KFC didn't exist and they said, hey, I got a fried chicken restaurant, I want to call it Kentucky Fried Chicken, I probably would tell them like, you got to think about something a little bit more creative than that, because that is pretty descriptive and it's going to be difficult to prevent other people from using similar terms, which is part of what you want to be able to do when you own a trademark.
Yeah. So one thing I've seen and it's something that I would like to do if I were to start another business. I love the power of using acronyms because I feel like you can get super descriptive in the title, right? Because it's an acronym for something. So you can tell people exactly what you do and you can shorten it up and literally create a word. So then I feel like it kind of gets into that, what did you call it? Fantasy or fanatical or fanciful?
Fanciful. Yeah. Fanatical would be cool too, but yeah.
Or arbitrary. So you can literally create words that have massive meaning depending on how creative you can get. So I guess where I'm going with this, where do acronyms fall in far of weak to strong?
Yeah, that's a good point. And something that a lot of people do miss. So like, I don't know if are they still around. TCBY, there was a yogurt chain. I don't know if they're still around, but they were popular when I was a kid, and I think it meant like the country's best yogurt. So the country's best yogurt is kind of a lame name to begin with, and probably pretty, not a very strong trademark. But TCBY is a good trademark because that's just a random, essentially combination of words and letters. So like from a trademark perspective, it doesn't really matter what the acronym means, right? So if your trademark is TCBY, that's a strong trademark, just kind of from a starting point. The fact that you then, tell people like, under that, it really means the country's best yogurt or whatever. Again, that doesn't damage the strength of that acronym based trademark. So that is a good way to go. If you have a term like you've got Kentucky Fried Chicken, okay, that's okay, but it's pretty descriptive and has a generic element. You compress it to KFC. Now you have something that is stronger from a brand protective perspective.
Now, so I don't know how you're the lawyer. Maybe you can tell me if I shouldn't be saying this, but there was an example that I could think of in Austin, Texas, where there was Austin Beer Garden. It was like ABGB or AB. I can't remember the exact acronym, but it's like Austin Beer Garden something. But then there was a bar that was opening in South Austin, and they decided to use an acronym, and it was South Austin Beer Garden. But it was two different companies, but they're both acronyms. So like, does that, I don't know, like, where does it get kind of wishy-washy in like that example of using acronyms? If the spelled out acronym is very similar, does it matter if the abbreviation is similar? Can you kind of bypass that, I guess is my question.
Yeah, and it's a good question. I mean, I have to look at the specifics of that particular situation to get into it. But I mean, the real question in terms of trademark conflicts, almost all the time, is this concept we call likelihood of confusion. Is the term that trademark attorneys use all day long, right? So the question is it likely that a reasonable consumer would be confused as to the source of the goods or services? Meaning, hey, I like Austin barbecue joint, whatever that place is called, right? I'm a fan of that. I like that. I'm driving through Austin and I see another
I looked it up
place.
if you want to know. It's the Austin Beer Garden Brewery. So
okay.
ABGB is what they go by.
Okay. I like Austin Beer Garden Brews. Like, I'm a fan of that place. I went to Austin one time. I ate there. Okay. Right. I go back to Austin. I'm driving around. Hey, I see another restaurant with a similar name. Do I, a reasonable consumer, think that they must be related? Oh, this must be, I think that's the name of the other place I went to. It's probably the same one. Maybe it's a chain. They have a couple different locations, right? As a reasonable person who's not like doing tons of research, but just sees the brand and has an impression as a commercial product immediately, do I think that there is a connection? That is called likelihood of confusion. So in terms of trademark conflicts, you don't, in most cases, need to prove actual confusion, meaning you don't need to prove that Eric was confused and thought that your beer garden was, the same type of restaurant as, the same company as my beer garden. You just need to show likelihood of confusion, meaning a reasonable consumer encountering the two products, doing, minimal research would think they came from the same source. So that is the theory that I would put to the test in terms of determining if if those two names are too close.
So, I mean, it would be Austin Beer Garden Brewery, and the other one was South Austin Beer Garden, and one's a literal brewery, and the other one's a bar that serves beer. It's beer garden.
I mean, both those names are pretty close to generic, right?
Yeah,
right. Because anybody can say, I'm in Austin. If you are in Austin,
well, it's a very unique example. Like all those things: Austin, generic; beer, generic; beer garden, generic. Right. All that's generic.
Right. So, neither of those brand names are terribly strong to begin with. So if either of them was to come to me and say, hey, we want to stop the other person from using it, I would say, well, look, your name is not really that strong to begin with. So it's going to be tough for you to enforce that right. There might be other variables, but just kind of taking the info that we have here. But kind of getting back to your original version of this question, if one of them was to sort of really go with the acronym as their kind of main branding focus, and then somewhere like underneath that or in smaller font or something it says South Austin Beer Garden or whatever, but it really goes by SABG, that may be a stronger position from a branding and trademark perspective than just the kind of more generic name, if that makes sense.
Got it. Any other details you want to drop on us regarding how to choose a strong brand? What makes them weak or strong?
Yeah, I mean, you just have to think about not just conflicts, like I said, but how strong is that brand? To begin with, what can I build on this? There is often a kind of tension between wanting to kind of describe and make it easy for your potential customers to know, okay, like this is a taco shop, right? As opposed to it's a lot of work to take a totally arbitrary or fanciful brand like Starbucks and create that impression of coffee in the customer's mind. It's a lot of marketing, a lot of advertising, because you're starting from nothing. They hear that word and it doesn't mean anything to them in terms of coffee. It may have some other meaning, but not in that context. So the question is, where do you want to focus your energy? Do you want to focus your energy on building that brand that's going to be really strong, but it does take a lot of work? Or are you going to start with something that's more descriptive? Or can you find something that's kind of a happy medium that still communicates what it's about, but also gets you that branding element that is going to be really valuable down the line?
Got
If
it.
you can find that sweet spot, that perfect thing, then it's then you really hit on something. But you got to weigh a bunch of different priorities. You can't always have 10 out of 10 on every category.
Got it. So we are jumping around. I do think I remember you hearing something along the lines of the number one thing that gets people in trouble. Did you already drop that on us?
Yeah. I mean, that's the fact that if somebody else has used the similar name, they're continuing to use it, that they may have rights, even if they haven't registered anything with the trademark office.
So you may have rights if you've been using a trademark for a long time. Is it because of the first,
Yeah, you get what's called
you're
common law trademark rights just based on use. Now, that may just be geographic. Like if you have a restaurant in Louisville, Kentucky, you may only have trademark rights in that region, and somebody in San Diego, California, where I am, they may be able, that may not be an issue. Again, consult your trademark lawyer to get into any of the details of a specific question. But that is something to look out for.
So on our agenda, we also have the trademark process. And correct me if I'm wrong, we really haven't dove too much into that yet, have we?
No.
We are back, and we're going to get into some trademark processes, or the process of being trademarked. So take it from there.
Yeah. Okay. So once we've kind of, cleared the brand, we've established what we think is a strong brand. We're not worried about any conflicts. Then the next step typically is to file the trademark application with the trademark office. That's what I do, or another trademark attorney. I handle that process. So a couple things to know about that. The trademark process in the US can take a very long time. Typically, I would say, under usual circumstances, it's like about a 9-month process from the day you file the application, you get the registration. That's even kind of in a good sense. Like it can be much longer. It can be years and years and years, but typically it's about 9 months. But right now, as we're speaking, October 2021, the trademark office in the US is extremely delayed, both because of COVID and because a flood of fraudulent trademark applications often from other countries, let's say China, for example. I have a lot of information about that on my website, but there's been a whole issue. So anyway, it's like a trade war that people don't really know about, except in my world. So that's really delaying things. So often now we're getting stretched out to a year or more in terms of that whole process. However, the good news is it doesn't mean that you have nothing until you get that registration, which can take months or years. The date that we file the application, in some senses, is the most important date, because that's when you get what's called federal priority. What that means is that you've made that claim to this brand and saying that you have the sole and exclusive right to use this brand in the US in context with these goods or services. And at that point, it's on the trademark database, it's online. Anybody else can search and see, okay, this is a pending trademark application. So you're already starting to get that benefit of that kind of invisible shield of trademarks, where people are just not using your brand because they see that you've already claimed it. The kind of rights will date back to that filing date. So it's not like you've got nothing, but once you get the final trademark registration in hand, that's when the kind of full rights start to accrue. And then really the good thing about trademarks is they can last literally forever. There's no expiration date, like Coca-Cola has been around for, 100 and more years. The rule in terms of trademarks is, again, a very simple, playground. My 4-year-old could understand this rule, which is use it or lose it. If you don't use a trademark for an extended period of time, you will lose those rights, even if you have the registration. you need to continue to use it in commerce. That doesn't mean you need to use it every minute of every day. You might close your restaurant for a month for repairs or to move to a different location. You may take a product off the market and kind of reformulate it or rebrand it, put it back on the market. That's okay. But the rule of thumb is about 3 years. So if you haven't used your brand name for 3 years, I wouldn't say that, anybody should just grab it, but from a legal perspective, it could be just kind of unclaimed. So that means you do want to make sure that you're continuing to use the brands that you've established and not lose them. It also means that if you're looking for conflicts and you see that somebody had used, let's say the same name as a restaurant, but they went out of business 8 years ago, then it may not be an issue because they've kind of lost their rights. I'm not telling you what to do. That's not legal advice. Look into it in detail. But
I feel like there's a lot of brands
it can last forever.
Yeah, and I feel like there's a lot of brands that open, say, in the past 3 years or 2 years. Like, say they opened in January of 2020, right?
Yeah.
And
good time to open a restaurant,
right? There's a lot of things that can close a restaurant, but when you're already on a a short budget, or you didn't properly capitalize yourself for being in business, and then you had to worry about all the expenses of COVID as well. I feel like a lot of business would have gone out of business. So I guess where I'm going with this is for those people who maybe opened in January 2020, but they still have all the intention to live out their dream, they just kind of need to regroup. What are some things they can do if they did go through the process of trademarking? Is it just as simple as keeping your Instagram page alive or something like that? Like, what can you do to stay active to kind of maintain that trademark?
Yeah, I mean, the main thing is to try to use it in the context in which it was registered or protected. So like for restaurant services. So like, let's say you had a brick and mortar restaurant and you had to close because of COVID or for whatever other reason, right? You may want to, for example, just do pop-ups or do a food truck under that brand name for, on and off for a period of time, just to kind of keep it alive. First of all, that's good for your customer base because they see that you're still out there and, hey, great. I like that food. I'm going to go check it out, whatever. But also from a trademark perspective, you do need to use it or lose it. But the level of use is pretty minimal in most cases. So you don't have to, be on every billboard in town. A pretty low level amount of use is sufficient. So yeah, that as an example, just having an Instagram page that you're continuing to post on once in a while, that might not be enough because you're not really delivering restaurant services. You're not providing any food to anybody. But even if you're just occasionally doing a pop-up truck or some kind of situation like that, that may be enough to kind of keep that brand in place, fixed in place until you're ready to kind of relaunch in a full location.
Got it. Any other elements of the trademark process that we have not touched on?
Yeah, I mean, even after you register, you always want to be vigilant and be looking out for conflicts to see if there are any others who pop up using the same or similar name. If that does happen, then often clients will come to me or another trademark attorney and try to deal with that issue, whether it's a cease and desist or whatever the right approach is in a particular situation. If you're going into other markets, you want to be aware of that. So by other markets, that could mean other geographical markets, like you could be moving to another country or expanding another country. You want to do searching and clearing and registering and protecting there as well, working sometimes with attorneys. I work with a lot of attorneys in other countries. It's very common for me. So a client will say, hey, we're expanding to Australia, and I'll bring in an Australian attorney and I'll collaborate with that person. Other markets could also mean products, right? So maybe all of a sudden your hot sauce in the restaurant's popular and you want to start selling hot sauce. Okay, so now that's another market. Do you need to do additional trademark searching and protecting to protect that brand name for the physical products? Thinking about those things in an early stage is good because if a client comes to me and says, look, I'm opening a restaurant, but I also just want to kind of I'm thinking about starting a barbecue sauce as well. So can we make sure that we're clearing for that as well? Even if we're not going to fully register and protect it right away, looking down the line, a year from now, we may want to do that. Okay. So then we can, include that in the search. But sometimes you go in unexpected places. We didn't expect to become a full catering company. We didn't expect to be this, that, and the other. So as you get into different verticals or different markets, you want to also go back and make sure you're kind of clearing up the trademark stuff on that end.
Got it. What about budgeting? If we're listening to this and we're thinking to ourselves, this is something I absolutely want to do, and we're trying to, establish our budget for opening, what money should we put away to go through this process?
Well, I mean, that's a situation where it's a little tough to answer because first of all, every trademark attorney is different. And also the costs are different depending on what you're doing. So, how much searching is required. The search process obviously has a cost to it. How many times are we going to have to do that, et cetera? Then the question is, in terms of trademarks, how many different trademarks do you have? Which ones do you really need to protect? Like a lot of people will say, I have a business name, I've got a brand name, I've got a logo, I've got a this, I've got a that. Okay, then part of what I do is working with the client and exactly asking that question. Okay, what is your budget? How much, can you spend on this? And what are the priorities? If you're coming at me and you say, look, I've got all the money in the world, I'm Jeff Bezos and I'm opening a restaurant empire. Okay, well then we'll file every trademark we can think of. Whereas for people that are, more on a startup type budget, we might prioritize and say, okay, look, it'd be nice to have all these things, but we'll do one at a time. Let's just protect the business name, the name of the restaurant. That's the highest priority. Once we've got that established, you've got some revenue coming in, things are going well, you've established it, you're happy with it. Then we look at the logo, or then we look at the tagline, or then we look at this, that, and the other. So you always want to find somebody that can work with you, understand what your budget is. It's going to be different for every restaurant and every business and every situation, but having somebody that can prioritize those things for you, help you. I mean, ultimately, you're the business owner, you have to make the decisions, but help you work that out, have that discussion is really a key. I mean, I do that every day. It's a key part of the process.
Yeah. Can you, I realize, and we got your disclaimer that every case is unique, but can you give us a ballpark like window, like low side, high side?
Yeah. I mean, if you come to me and or a trademark attorney, I mean, I don't know what everybody's rates are and fees and things like that, but if, typically what you're looking at in terms of like clearing the trademark, doing a search and then doing a very basic, registration on, for a simple, application, like one class of goods and services, meaning like just restaurants, but not also this, also that, et cetera.
Just
right?
the name of the business.
Right. Typically you're looking at a couple $1,000s in terms of ballpark. That's not typically tens of thousands of dollars. It's not a few $100s. So that's just kind of the range you're looking at.
And what are the costs that are associated with not going through this process? What have you seen as far as people being sued or anything along those lines? How do you justify the $1,500 investment?
Right. So, I mean, the big thing that happens to people that I deal with all the time, on both ends of, in terms of both being protective and defending and all those kind of things, is somebody has a restaurant and then, they start to get some traction and everything goes great. They get some good press and then boom, they get a cease and desist letter from a lawyer like me saying, hey, you need to stop using that name because we already have it, we have rights, et cetera. Now that may be right, that may be wrong, but we do kind of see that happen a lot. And to rebrand and pivot and change your logo and your menus and your signage and everything, you can imagine is very costly and time consuming. Sometimes it's a positive thing because sometimes somebody's like, look, I just didn't like this brand anyway. I think we've got a better name now that so, sometimes people can see a silver lining, but generally speaking, it's not a conversation I like to have. I much prefer it when things are done ahead of time, the clearance, the protection, everything, because, otherwise that, I've seen clients just go out of business because they can't afford to make that change, in midstream. And that's really more than getting sued. Yeah, getting sued happens, but it's pretty uncommon. Most of the time, people just kind of get that letter, they start talking to the attorney and they realize I'm out of luck. It's just there's not even a lawsuit to fight here.
Yeah. And I mean, just because it's relative right now, we did have a question coming through. Would you go to services like LegalZoom to do this? I mean, I don't know why I see the conflict of interest of you promoting a service like LegalZoom.
Well, it's not. Yeah. Here's what I would say. This is my own business. I've had this business since 2005. My wife has her own business. We also own a model railroad museum. So we are in the, customer service type business as well, in terms of having a retail store and so forth. So I totally understand, all the decisions you have to make in terms of business. What I would always say is talk to a trademark attorney or a couple of different trademark attorneys if you can, or business formations or whatever you need to do. Get that information and then see if it's right for you. I tend to see the bad side of things like LegalZoom, not because they're bad, but because if something isn't done right, then somebody comes to me and they have to pay me more money to fix it. But that doesn't mean that it's not working I only see the ones that don't work out. You know what I'm saying? Like the people that it does work out, they don't come to me. So I have no way of knowing if it's good or bad. It might be right for you. Everything might be the right solution for you. It's like, which point of sale system are you going to use? This one's more expensive, but it has this. This one's cheaper, but it has that. there's not one right solution for everybody. So, if you're just starting out at a very low level, hey, we're just doing a pop-up at a farmer's market, I can totally understand how, you're probably not going to spend thousands and thousands of dollars on legal fees if it's just, you're just trying to see, okay, we're gonna do this for a month and see if people like this Thai food. Versus if you have a more developed business plan, investors, okay, that's something where you may benefit from, a little bit more personalized advice. So it's not for me to say one thing is good or bad, but I can't tell you in a specific case if something is really working or not.
Beautiful. So we've kind of gone through the agenda for today. I do need the whole point of having you here is because somebody did approach me with a specific question about trademarks. And I kind of want to lead off the Q&A with that question, and go ahead and throw your hand up if you want to. Starting now, if you guys want to ask your question, go ahead and put your hand up. We do have your questions that are in the chat as well. We can start going through and asking those questions. But the specific question I have for you is in the example of, say, there is a brand that exists. At one point, it was it was a larger brand. There were more locations, but that was way back in the 80s, right? And over time, the brand has kind of gotten tired. Locations have closed. There's only 4 locations for this brand, right? And you own one of those locations as a franchise. And your dream, your plan is to absorb the remaining 4 locations and then scale. Regarding trademark, what things do you need to keep in mind?
Yeah, I mean, you want to understand how it's been used and in what context, like what, is it just restaurants or are there other products and so forth? Were there other products in the past? You want to possibly do the search to make sure that there's nobody else who's come along who just thinks, oh, that brand is dead, I'm going to start using it or something similar. Because the franchisor, the company that owns the brands and the franchises, they may not have been policing. They may, because it's been contracting, they may not have been spending the money or the time to be active in policing it. And if you don't police a trademark for long enough, other parties can gain rights, whether that's local or whatever else. So that the rights may have shrunk over time just because they weren't enforced and weren't properly taken care of. So that's something where you're going to want to do your due diligence. And then most of the time the franchisor, the company at the top, they're going to own all the brands, all the trademarks, registrations, so forth. You want to make sure that all those registrations were maintained and sort of done properly, because there is maintenance, there is renewals and things. So even if they had their trademark filed and everything was done properly in 1985, that doesn't mean that it was maintained. That doesn't mean the registrations were renewed, et cetera. So, there is a benefit to, speaking to an attorney who can do that due diligence to make sure that what you're looking to acquire or grow is something that is in good shape.
So the 3 questions that I pulled that we need to consider: 1, do you still have the rights? Meaning, was the brand that owned it before you, or the individuals who owned it before you, policing? Was the registration renewed? Things like that. Like, are you still protected? Don't just assume because this is a pre-existing brand with trademarks that those trademarks hold up.
Right, exactly. There could be vulnerabilities, and it's worth doing that research just to see where you're at. It doesn't mean that, that it's not an either or type of thing. It may be gray area. Okay, well, there's problems, we can fix them, or here's what your options are. But again, you do need to really get advice about that.
And if your plan is, if your family's bought into this trademark or this franchise, are there things you need to consider as far as purchasing trademark, or is that just encompassed with purchasing the organization? Is there a price tag to a trademark?
Yeah, I mean, that's a good question. I mean, just owning a franchise, the individual franchise doesn't give you any rights other than what's in the franchise agreement, which is a license. So the franchise agreement will say you can do this, that, and the other, but you're very limited in terms of what you can do with the brand. You don't own it. It's just you have the right to use those brands, the name, logo, et cetera, in certain contexts following the terms of the franchise agreement.
So if you purchase a franchise, is the legal aspect of trademarking encompassed with that purchase? Or
yeah, so if you purchase a not Starbucks, they don't, but Subway, let's say, franchise, right? So like all you have the right to do is to operate that Subway franchise, that Subway sandwich shop in that particular location, and to follow the rules. So just like you have to make the sandwiches the way they tell you, you also have to use their trademarks and brand names and logos and things like that the way they tell you. You can't change the colors, you can't change the font, you know what I mean, you can't rename the sandwiches, etc. You have to kind of follow the rules. So
yeah, so until you do own it, don't get too creative.
Right. Until you, you know, if you were to buy now, if you buy the whole franchise company, you know, the company at the top of the chain, then you own the trademarks, everything goes with it, and you can make the changes you want and so forth. But until you get to that point, you need to be in compliance with your franchise agreement at all times, or it could be pulled from you.
Yep. Awesome. Got it. All right. Let's open this up to some attendee questions. And if you guys are going to be joining us, feel free to tell us who you are, where you are. If your questions are personal and you don't really necessarily want the world to know who you are and where you are and what you're doing, you can be just don't say your name. Just ask your question. I won't hold you to that. But starting with, actually, I won't even say your name. First person with their hand up, feel free to introduce yourself, tell us who you are, where you are, and ask your question.
Thanks, Eric. I like your shirt.
Yeah.
So my name is Greg Lindsay. I have Jewish Deli in Alexandria, Virginia. So I had actually,
I love that. I love the name. That's very clever.
That's awesome.
I see names all day long, so that's a good one.
Well, one of the best investments I made in my business was hiring a marketing company to help me with the initial branding.
Yeah.
And part of their process was actually doing a trademark search and doing a search into the name to make sure when we did some naming that there weren't going to be any issues, you know, in at least the short term. So I was grateful they did that. So I looked into the trademark process at one point, kind of, you know, a couple of people said, oh, you can probably do it yourself, which does not seem to be the case once you start looking into it. And one of the things that confused me is that it looks like when you go to the website and look at their applications, they have like two different levels, one that costs more than the other. And it almost looks like it's just a more streamlined process that you're paying a premium for. It was a little confusing. I'm not sure if you can speak to that a little bit.
Yeah, you know, their website is not the most user friendly. You know, for somebody like me that's been using it every day for you know, whatever, close to 20 years, I'm fairly good at navigating it, but even I sometimes like, wait, where is this? So it is sometimes confusing. There's a couple different types of applications that do have different prices. Some of that has to do with whether you're describing the goods and services according to like a formula that they already have, or if you're just kind of freely writing it in. I do both of those depending on what my client needs. You know, if you're a restaurant and it's just restaurant services, that's pretty simple. You could do what's called the plus form, and it's simple. You just click to do that, and it's a little bit cheaper. Whereas if you're doing something that's kind of a new product, you know, somebody says, oh, I've got this new, you know, Bitcoin product, whatever, something that's totally new that really hasn't been described before, then sometimes we have to use the kind of older form, which has a different additional fee to it.
Okay.
But yeah, it is, look, people file their own trademarks and it's successful and it works sometimes, and that's fine. You know, studies have shown that, you know, when you go with a lawyer, you are more likely to have a successful process. That makes sense. I mean, you know, if I was going to try to, you know, make a brisket, you know, you'd probably have a much more likelihood of success than I would. But you know, that doesn't mean that you can't do it yourself. It just means you might run into issues.
No, thank you.
No follow-up questions, Greg?
No.
Awesome.
The only thing I would say to that is, for people who are outside the U.S. who want to register their trademark in the U.S., you do need to use the United States-based lawyer. So if you're in Mexico, but you're expanding your restaurant brand to the United States, you would need to hire an attorney that's licensed in the U.S. to file. But if you're a U.S. resident, you can file for yourself if you want.
So I've got some retail products associated with my brand, and another very large international company has used one of my product names, and as far as I can tell, I had it first, and it's not something very generic. And so nothing, you know, they haven't sent me anything yet thinking that they have rights to that. I haven't sent anything to them yet. I do not have it trademarked, but that's something I'm looking to do with all of my product brands. Just wondering how big of a hill am I going to have to climb with them potentially, since they have much deeper pockets than I do, regardless of who's there first. You know, let's say I'm there first. Does that really mean anything? Or is it whoever has the deepest pockets wins?
Well, you know, it depends. You know, I'm thinking of a particular case where I had a client who had a brand name, and so I can't say who it was, but a very big social media company that everybody uses all day long came along and they started using a very similar product name for a similar space. The client said to me, like, what are we going to do? You know, they have so many lawyers. And I said, well, you only need one. And we did win. We got them to back down. We didn't have to go to court. You know, it was all letters and phone calls. And they were like, no, we can't fight this. I mean, even though they had the money, like, big companies still don't want to spend money on litigation they don't need to. So it's not true that if a big company comes along, you're out of luck. Typically in that situation, again, I'm not your attorney. I don't know the specifics, but typically in that situation, we would file the trademark application, at least to get that application filing in, and then sometimes proceed with a cease and desist or whatever the other approach would be. Because once you have that application filing in the trademark office system, you're coming from a stronger position. So even though you haven't registered it yet, you're kind of pending and they can't file, they're kind of out of luck in terms of filing it. So that might be an example of a strategy to kind of build your strength before you approach them. Again, I don't know that would be the right strategy for you or what I would recommend once we get into the details, but there's different kind of ways to approach it is the answer.
Is it typically deemed reasonable to give either party, whether it's my company that has to make the change and stop using the trademark or the other company? Is it, when it comes to like tangible goods like that versus something that's online, something that isn't being delivered all over the world and things like that, is it typical to give the other party a reasonable time frame to remedy that? 30 days, 90 days, when your labels run out, things like that?
Yeah, that's very common, is to have a sell-off period in terms of trademark use, unless it's like really urgent, like, hey, I'm launching my commercial with the Super Bowl next week. We got to stop you from using it right away. That's a very limited set of circumstances. Most of the time, the other party has a sell-off period or a reasonable period of time to change. And another thing that does happen sometimes is there are coexistence agreements, meaning you may have a similar trademark, your brands may be somewhat similar, but not identical. Maybe you're in different verticals, you're attracting different markets or something like that. And so you'll come to an agreement whereby both parties can use their marks and both parties can file registrations and so forth. They're just agreeing not to conflict with each other. So that may be an end result as well. I don't know.
Okay, sorry, 1 second. I had some like kind of random questions. Actually, I have a question real quick, something you've mentioned a couple times.
For your question, do you want to tell us who you are and what you are?
Oh, yeah, okay. My name's Jared. I work for, I own a company called Su Madre, which is contracted by Eric and Restaurant Unstoppable. But you've mentioned this a couple of times, and I'm curious. If I am going through the process of registering a trademark, and you said it's backed up and it takes 2 years, while it's pending, no one else can put in another one to be pending at the same time with the same name. Is that true?
That's basically right. So if I applied to register, Restaurant Unstoppable for podcasts, and even though it's pending, and then a week later somebody else came along and tried to file the same exact trademark, the trademark office would bounce them without any question. I mean, it would be obvious that there was a conflict. Now, if it's somewhat close or whatever, that's different. But if it, somebody had this, more or less the same name for similar products and services, that's a big thing the trademark office does. That's part of the why it takes so long. It's not just like you file something and then boom, it applies. They have attorneys who have to review every single application to see if there are conflicts in their database. And they reject applications all the time on that basis. So yeah, once you've got that filing, anybody else, who comes along who tries to file an identical or similar mark in a similar space, most likely is going to get rejected on that basis.
Okay, that's like comforting. I'm glad that you clarified that. I have a few more like smaller questions that I'm just curious about. What about a reference to a copyrighted material? Like, let's say I wanted to open a cinnamon bun shop and call it Princess Leia's Cinnamon Buns.
Yeah, I mean, I wouldn't use Princess Leia in any context because that, is the Disney empire.
Just as an example.
I hear what you're saying. That happens all the time. So, you might have a, kind of a sandwich shop that, the name is a reference to a Grateful Dead song or something, right? I mean, like that, you see a lot of that. Typically it's a case by case thing, but typically if it's kind of a obscure reference or you're just kind of hinting at it or making a joke, that's, often is okay. Like, nobody really cares and it's not really an issue. Whereas if it's something, really right on target, Harry Potter, sandwich shop or whatever, then you're probably going to be totally out of luck. So there's no, there's no bright line here. There's a lot of gray area, but that can be fine. But the more kind of
obvious
of an inference it is, the better you are.
Okay, my final rather small question would be, what about titles that are in the public domain? Let's say I wanted to open a pet shop and call it The Island of Dr. Moreau.
Yeah, I'm assuming that title is in the public domain. But yeah, I mean, if you wanted to open, Romeo and Juliet, dating bar, whatever, singles bar, right? Maybe that didn't work out so well for them, but you know what I'm saying. That's that's totally fine. It's in the public domain and anybody can use it. So there's tons of like Shakespeare Pub or whatever, right? So those are all public domain. And if something is truly and honestly in the public domain, which sometimes is hard to tell, right. But if it really is, it's like before 1900 or whatever, then then anybody can use it, and you can be whatever, Sherlock Holmes coffee shop or something. I don't know.
Okay.
I have a couple questions and I think we can start to wrap it up. Real quick, should I trademark Are You Feeling Unstoppable today?
If you are using it as a trademark, like as a brand,
what if I say it at the beginning of every episode?
Yeah. So things that are only in audio format can be difficult to prove use as a trademark. Doesn't mean it can't be done, but usually when we're proving use as a trademark, we're showing screenshots or some kind of visual evidence of use. So for a restaurant, it's really simple. Like, here's a photo of the sign, or the menu, whatever it is. There's no question. For something that is like more of an audio tagline, that would be a fun project for me because it's a research project and I'm sure people have done it, but it's not something that happens all the time. So we would need to kind of figure out how to show that you're really using it as a trademark.
Got it. And you got into earlier pointing out that a trademark is not a patent or a copyright, but for the sake of understanding, are there any examples you can think of where a restaurateur might want to use a copyright or might want to use a patent, and where in their mind they might be thinking trademark?
Yeah, so totally. It comes up all the time. So a patent is a exclusive license by the government to use or create like a certain invention. So you need to invent something in order to get a patent
Like
that
a
is
process
useful,
that like make
useful,
McDonald's
novel,
use it.
etc. It could be a process, it could be a business process, it could be a software product, it could be a physical product, right? But things like recipes are very, very difficult to protect under patent law. I'm not a patent attorney, but I do work with them, so I know like a little bit about it. Patenting is a whole separate process. There's a whole separate patent filing system and so forth. You don't get patent rights just through use like you do through trademarks. You have to go through the process in order to get any rights as a patent. So sometimes people in your space may come to me and they say, hey, I have something that might be patentable, an invention, a new way to bottle beer, whatever it might be. I don't know,
Listening to you talk, I think like a franchise would be something that you patent because that's literally just a system for doing something.
A franchise is different because every state has its own franchise registry. So that's a whole nother area of law where if you are going to do a franchise, great. But we would bring in a franchise attorney that just specifically works on that. And that's a really complicated state-by-state area of law. In terms of copyright does come into play in the restaurant industry. So copyrights are a right or a group of rights that are exclusive that apply to individual works of creativity. So anything from a written piece of work to an illustration, a logo, things like that can fall under copyright law. So you can see how a logo could be protectable as a trademark, but also a copyrightable image. They're two separate things. So sometimes in a restaurant world, we might want to achieve, copyright protection for a logo. Sometimes for written works, I mean, a menu, typically there's so little writing that's creative that it doesn't fall under, meet that threshold for copyright. But if you do have, a really creative menu or something on your website that's, really interesting writing, or your story, that may be potentially copyrightable and protectable. Again, it's separate from trademark. It falls into a whole different world. Probably would be a whole separate conversation, but I do work with clients on those things as well.
Beautiful. I think that's all of our questions. David, thank you so much for taking the time to join us today and to enlighten us on the subject of trademarks. I learned a lot personally. I can say that. If we're interested in using your services, we want to reach out to you, what's the best way to connect?
Yeah, I'm happy to talk to anybody or help. Point you in the right direction, whatever it might be. Best way to find me is through my website, lizerbramlaw.com. If you type in David Lizerbram and you even get close to spelling my name right, you'll find me. There's only one of me. So I'm very easily findable. At David Lizerbram on Twitter, etc. Yeah, I'm pretty easily found. So yeah, feel free to reach out. I work with clients all over the country and all over the world, helping them with everything from business formations, contracts, LLCs, corporations, etc. And then obviously a lot of trademark work as well. Very common for me to work with companies in the hospitality industry. And it's a lot of fun because sometimes I get to visit them and enjoy their products, which is not always the case when I'm working with an insurance company or something. That's great, but it's not quite as much of a good time on a Friday night to take my wife and enjoy it. So anyway, thank you all for all you're doing. I know it's been a hard year and challenging, and continues to be with employment issues and all those other things that are going on in the hospitality industry. So I know you all are working hard to serve people, to provide people a good experience, and to build businesses for yourselves, your families, etc., support your employees. Those are all great things. And if I was able to help in a small way today, then my day was worthwhile. So thanks a lot.
David, it was a pleasure talking to you. I'm going to spell that last name for your website. It's Lizerbram law.com. So lizerbramlaw.com. Feel free to reach out to him, and just thank you so much for taking the time to join us, to share your wisdom, your knowledge around trademarks. There is no questioning, David. You are unstoppable.
Thanks.